are going to give everyone a couple more minutes to log in. So please hang tight. We'll get started in about 2 or 3 minutes. For those who are just joining, just hang tight for another minute, and we're going to get started after we give people another 30 seconds or so to log in. All right, why don't we get started? Thank you all for joining us virtually. This is the TMA Detroit's Bankruptcy from a Borrower's Perspective. Hope you're all having a good day and a good week. I'd like to start off by thanking the gold sponsors and all the other sponsors you see here. The gold sponsors are Glass Ratner, Crestmark, Dickinson Wright, and First Business Capital Corp. Thank you all very much. And you can all see the other sponsors on the list here. Here's our 2020-2021 TMA Board of Directors. Thank you all. And upcoming events for the TMA Detroit, December 16th. It says here 2002. I think that's actually 2020. From 4 to 5:30. Should be a great event. I've already signed up. It's a virtual holiday party and wine tasting where you'll get wine, cheese, and chocolate. And so registration links are on the TMA Detroit website, or you can email Detroit@turnaround.org for more information. We are lucky to have a great panel today. So let's get started. This is the fourth part out of 4 webinars that TMA Detroit is doing in a workout bankruptcy series. So hopefully you were able to watch and participate in a couple of the other webinars. Just a reminder, we're going to go till about 4:45, 5 o'clock or so, and then after that there should be about 30 minutes of virtual networking. There will be a link that should have been sent out already. If you don't have it, it's also going to be put into the chat function here on Zoom. So let's get right to it. I'd like to introduce the panel. Laura Marcero is a managing director at Huron Consulting Group, where she leads the restructuring and turnaround practice, as well as the Midwest region. Laura has provided services in automotive, manufacturing, healthcare, higher education, travel management, restaurant, retail, among other industries. She has served in various interim management positions, including Chief Restructuring Officer and Chief Financial Officer for public and privately held companies. And Laura is currently serving as the CRO for Town Sports LLC and recently served as an independent board member for a $2 billion travel management company. Next, we have Roy Vorhees, who's an investment banker with Donnelly, Penman and Partners, where he focuses on middle market transactions, primarily within industrial and automotive markets, many of which are special situations or distress-driven sales. Prior to joining Donnelly Penman, Roy held positions as director within the transaction services practice of PwC and senior manager in the audit practice of PwC. Roy is a registered CPA and received his undergraduate degree from Michigan State and an MBA from Michigan. Next, we have Amanda Vintevoghel, who's an attorney with the Dragich law firm PLLC, a firm that helps businesses navigate the day-to-day challenges and intricacies inherent in their operations, with a specialized focus on corporate restructuring. Amanda represents debtors, creditors, assignees, receivers, and other third-party fiduciaries in a wide variety of bankruptcy and insolvency proceedings. Currently, among other engagements, Amanda represents the federal court-appointed receiver of a Tier 1 automotive supplier in the Eastern District of Michigan and is involved in multiple receivership matters throughout the country. Amanda has also represented several debtors in Chapter 11 proceedings in a variety of industries in Michigan. My name is Josh Gadharf. I'm a partner at McDonald Hopkins PLC here in Michigan. I'm in the business department as well as the business restructuring services department. My restructuring practice involves navigating companies through in-court or out-of-court restructuring processes. I also regularly serve as general outside counsel for non-distressed businesses. McDonald Hopkins is a full-service law firm with more than 140 attorneys in offices in Detroit, Cleveland, Chicago, Columbus, and West Palm Beach. So hopefully that's the most speaking I do today, but we'll see. So let's start off. So hopefully some of you have already seen the out-of-court workout from a borrower's perspective. So what we're going to kind of do is pick that up from there and talk about what happens when an out-of-court workout cannot be accomplished. When do and why do borrowers choose the bankruptcy process? So I'm going to start off with Roy. And Roy, in your experience, can you talk about why the bankruptcy process has proven helpful for a company experiencing financial distress?
Sure, Josh. I think, first of all, I think that from a decision about whether we're going to go into bankruptcy from a Chapter 11 versus 7 or a wind down, for me, it's kind of simple. It's really whether that business has a reason for being. And I think there's 3 maybe potential drivers for that, whether it has a reason for being, whether it's got a long-term going concern value that it's greater than the asset liquidation. And one is if it's generating cash flows or has a road to profitability that exceeds the value of the assets. And maybe it was over levered or an event-driven situation drove it into bankruptcy. Another would be if there's a customer need. And I think there's just many examples where automotive, in auto land anyhow, where OEMs need to protect their supply base, maybe are unable to efficiently transfer business to other suppliers, or look to support a distressed supplier to affect a sale. And then I think the other one that is in the category of where you have a synergistic buyer. Maybe the business that is distressed provides a technology, capability, capacity, book of business that has value to the strategic buyer that's greater than the standalone value of the.
Thanks, Roy. Yeah, that makes a lot of sense. So on these couple slides, we kind of put together a decision tree that companies think about when they're going to be considering a bankruptcy filing. And if you look at this part, all of this basically happened during the out-of-court workout phase. And if it's successful, then that's the route you take. Laura, in my experience as an attorney, I often talk about the need to have an exit plan before you enter bankruptcy. Is that your experience? And maybe you could talk a little bit about when a financial advisor such as yourself gets involved with a company that's considering a bankruptcy filing.
Sure, Josh, happy to. And thank you again to everybody for participating today. Much appreciated. And look, a lot of times the financial advisor is brought in when the company trips meaningful covenants with its lender, and or the lender loses confidence in the capability of the management team to navigate the set of challenges that it faces. So typically what will happen is the lender will give out a couple of different names to the company to interview for financial advisor. Legal counsel may or may not be already involved. And then once the company selects the financial advisor, from there, really you go into a very quick mode of trying to assess the situation, whether it's creating weekly or monthly cash flows or both, but really trying to determine what the set of circumstances are, what can be done, hopefully out of court, or assessing that there is a need to go into Chapter 11, for example. But really trying to identify what will be the ultimate solution set here, whether it's some type of reorganization, sale, combination of the two, shuttering of operations, what have you. But typically the financial advisor gets brought in at that point when the lender has lost confidence or has deep concerns about the company's ability to navigate the situation on their own.
Great, thank you. So Amanda, as an attorney who represents businesses, when do you normally get involved? And if you could talk a little bit about some of the initial advice that you give to clients, management teams of the businesses when you first get engaged.
Yeah, thanks, Josh. Well, I would say, when the legal counsel gets involved can be two different scenarios. To use a sport analogy, it's whether the bankruptcy is used as an offensive manner or a defensive manner. When I say offensive manner, I mean, if there is a sale that's going to take place where the buyer only wants to do a sale in a 363 context, or if there's another lender who wants to come in and provide exit financing, but they want to extinguish all of the prior debt. Typically in those scenarios, the legal counsel has been involved for a while. Like Laura indicated, sometimes when the lender loses faith, the financial advisor comes in, the financial advisor recommends counsel. And so in those cases, you've been involved for a little bit. However, when you're in defensive mode with a bankruptcy filing, meaning you have creditors caving in on you, there's a pending foreclosure action, there's a pending deadline on a forbearance agreement, then you're usually the last one to the table. And usually it's the day before the deadline, sometimes the same day as the deadline. So usually legal counsel in the defensive world, you're kind of last one to the party and trying to play catch up before you give a lot of advice on what path to take. Leading me to the second question you asked about, what are the initial conversations you'd have with your client. From an officer's or manager's position, you want to make sure that they understand that the shift in their fiduciary duty that comes into play. If a business is operating profitably and things are going great, your fiduciary duties are to the shareholders, the members, etc. But once you get into that zone of insolvency or you file bankruptcy, that switches. Your fiduciary duties are to the creditors of the company. So sometimes that's a message not well received by the parties in control of the business, but I do think that's an important point you have to reiterate.
Yep, and sometimes that, just Amanda, to follow on with your comments, sometimes that involves having that discussion with the board, and in some cases putting in independent board members as well. But I agree with you, those conversations can be quite challenging from time to time because it is a mindset shift, particularly in the privately held businesses.
So Laura, why would a independent board director be installed with a troubled company?
Well, look, the decisions are tough, right? Frequently, they're incredibly difficult for the existing either management team or owners of the business to sometimes accept or to make the tough decisions that are necessary. So having an independent board as a whole, or perhaps a few members that form a restructuring committee that would then make recommendations to the board as a whole, is a good vehicle by which, you know, you can demonstrate to all the other constituents that that impartial and the impartial decisions are being made with the best interests of the creditors, as Amanda mentioned, and frankly for all of the constituents. And it's quite helpful, particularly if there's skepticism either with, again, management or ownership. Installing that independent board, it can really help take some of the tension out of the room and give confidence to the other constituents that that folks that perhaps don't have a vested interest will be the ones that are helpful in approving those tough decisions.
Yeah, yeah, and oftentimes I've seen, you know, the senior secured lender use their powers as they have in their loan documents to actually install an independent director and remove the entire board. So that can happen very quick, where the management team or the board can lose control. But Roy, let's go back a little bit and talk about this kinds of discussions that you might have to have initially with management or boards of directors, because you may get involved sooner than Laura, almost always sooner than attorneys. How are you received by a borrower who is facing a decision about whether they need to sell their business?
Yeah, so we end up getting involved in all different stages when working with underperforming companies, Josh. And I think ideally it's pre-bankruptcy, and at that stage, oftentimes I think that hopefully we're received fairly well, in the sense that the way that we see ourselves as providing value as an investment banker is to create options, create alternatives. In pre-bankruptcy, we have more options than post-bankruptcy. As an example, I guess right now we're working with a small company whose customers' end markets have softened during the pandemic. They serve mining, oil and gas, some industrial markets, and they're limping along with some debt covenant violations, et cetera. And so the options that we're trying to lay out for them at that earlier stage is to have a range from improving and keeping the business, to infusing with capital, to selling the business to a strategic partner, through or outside of bankruptcy. And it's those options that we're trying to create that I think from a borrower's perspective could potentially be attractive.
Yeah, just Roy, to follow on to that, right? I mean, it's running multiple paths, as you're suggesting, at the same time, right? To increase the optionality and leave no stone unturned when you're trying to maximize the enterprise value as a whole. So you guys do a really great job of that.
Thank you. Exactly. Well said.
Well, so, you know, we obviously don't have enough time today to get into each and every possible bankruptcy scenario. But this kind of chart shows kind of the options that we have as a borrower. So the out-of-court restructuring hasn't worked. You're going to file some sort of process. Oftentimes, companies file something called prepackaged bankruptcies or prearranged bankruptcies, where they shore up creditor support prior to filing, and the case is supposed to run rather quickly. You still have to abide by bankruptcy law and check all the boxes, but creditor support, as we may get to later, is one of the most important things if you're going to have a successful reorganization. Another option is a longer Chapter 11, which most people think of as like a traditional Chapter 11, where the company is attempting to emerge on the other side as basically the same company, maybe with different ownership, maybe a different capital structure, different debt structure. And then the fallback options. You have a free fall Chapter 11 where, like Amanda was saying, your creditors are pounding down your door and you just file an 11 to get them to stop for a little bit. And then you have more of a liquidation scenarios where Chapter 7, assignments for the benefit of creditors, receiverships, or just an out-of-court wind down where you try to slowly and quietly shut down the business. So let's talk more about the Chapter 11 and some of the key considerations. Amanda, you kind of already touched on the shifting fiduciary duties when a company is insolvent. So I think that that's a very important point, that the management and the board don't necessarily owe the same fiduciary duties. So if you don't mind, can you touch on that a little bit, and also talk about what happens when the bankruptcy case is filed, and how does that affect issues that the company might be having right before they file?
Sure, right. Yeah, to kind of close the loop on the fiduciary duty element, I mean, that means the management or the current board or the interim board would have to ensure that every act they're taking from the filing date on, or even prior, again, reference to the zone of insolvency, is taken for the benefit to ensure that the value available to creditors is the highest possible. So that's just one overlaying thought that obviously has to be in mind throughout the whole process. In regards to the second point we have up here about breathing room, one of the benefits of a bankruptcy is the automatic stay that may not be available in other restructuring methods. The automatic stay stops everything from collection efforts wise and allows the company to have some breathing room to evaluate their options, whether that be they are continuing to operate, whether they're ramping up for a sale process, or they're ramping up to liquidate, unfortunately, and just create a liquidation trust and move on. But it does allow the borrower their time to analyze all those options. And then also, it also provides the debtor the opportunity to review any contracts or leases that, I know we might discuss that later, but gives them an opportunity to review those to see if there's anything that's too burdensome and that's what's causing the problem for the business, or that's not helping it anyway. So it just gives you the opportunity to pause and focus on your business and focus on how you want to fix things going forward.
Yeah, we can talk about the unique ability of a borrower in bankruptcy to deal with their contracts. Laura, I think we've talked about this before, but from a business perspective, how does a bankruptcy really enable the borrower to reassess its contractual obligations and make a determination about what it wants to do with its contracts and leases going forward?
Yep. Josh, it's a good question, and we've had this in a couple of different industries primarily. One of which is taking place now with, for example, the gyms that are all being impacted by COVID and entering Chapter 11 and considering which leases may need to be rejected gives you an opportunity to shore up the footprint, if you will, and exit some of those leases that maybe just too expensive, or certainly too expensive in the current environment. We've also had it in restaurant and franchisee cases, one of which we worked with you guys on a few years ago. But it really gives you the ability to right size your footprint and exit those unprofitable contracts, or look, in some cases, renegotiate them in a very substantial manner that helps the company be on much solid footing coming back out the other side. So it's one of the primary reasons, if you have to go into Chapter 11, particularly in a middle market case, that would be one of the ones that is really tough to do in as meaningful of a manner outside of bankruptcy. And it's a bankruptcy tool that you just have to use in some of these circumstances, like the two industries that I mentioned in particular.
Yeah, and just to reset a little bit on leases and contracts, the bankruptcy code does provide that a borrower or a debtor in bankruptcy can assume or reject contracts. And you see this chart kind of goes through that process. So once you file a bankruptcy, the company, to the extent it hasn't decided to assume or reject, has to continue performing, as does the counterparty to that contract, regardless of whether the borrower has an outstanding balance due to that counterpart. So, for instance, in a lease, so that the borrower can stay at the leased premises, even if they haven't paid rent for 3 months, as long as they come current after the bankruptcy filing. And then if they decide to assume that lease, for instance, they would have to then cure all of the outstanding pre and post petition defaults. So that's a really important consideration that borrowers have during the case. Now, Roy, in regard to contracts and leases, that kind of plays into your world as well, I would think, because a party who's interested in buying the assets of a company out of bankruptcy probably takes a lot of hard looks at the contracts, right?
Yeah, definitely, Josh. I think all the reasons that you've stated as far as contract review, the clean title to the assets, the automatic stay and DIP loans all provide a benefit to a successful sale out of bankruptcy. The clean title provides something that the buyer is looking for. The automatic stay, like Amanda alluded to, the automatic stay and the DIP loans provide some flexibility so that there's time and flexibility to find a buyer and to get a deal done. Another thing that we've seen is customer accommodation agreements that can help demonstrate to a buyer sustainability of a book of business or commitment to a customer. So I think for all those reasons, the other thing that I think that sometimes the Chapter 11 helps with is that from a buyer's perspective, they believe that a transaction is actually going to happen here and that it's likely to go off at a reasonable value. So they're willing to, oftentimes they're willing to devote the resources necessary to vet it and to get it done.
So I think we should drill down on 363 sales. I think a lot of people probably on this webinar are familiar with that term. Before we get there, though, let's talk about a traditional Chapter 11 case, which there's, you think of that as a company that files bankruptcy. A United Airlines files bankruptcy, and they take a year and a half or two, they file a plan, they come out, and they're still called United Airlines. Those cases aren't as popular anymore. They're timely, they're time consuming, costly, and oftentimes people go the 363 sale route. And even in that scenario, the buyer can still use the same IP and trade names that the debtor has. So from a customer's perspective, it sounds like the same company. But this chart kind of goes through the timing of a traditional Chapter 11. Amanda, can you talk about from a legal perspective, and then we can talk to Laura a little bit too about the DIP financing and cash collateral, the means that for a debtor to finance its case, because a Chapter 11 can't really go forward unless it has financing.
Right, and that's a fairly large point. One of the first things you'll ask your client when you brought in and deciding whether you're going to file Chapter 11 is, do you have money? Because obviously we all know that it can get very expensive to have a Chapter 11. So it is beneficial to either have the funds yourself, being the company, or to have a DIP lender. The DIP lender would typically be sought, right at the petition date. It's usually one of the first motions that are filed to, obtain a DIP lender. And they will, come in and finance the operations or the wind down of the company, depending on what the Chapter 11 goal is, while the Chapter 11 case is going on. So they will cover, all of the operating expenses, the costs associated with reporting to the, which we'll talk about more, to the U.S. trustee and things like that. Also, the DIP lender has to be approved by the court. So there has to be some sort of super priority status that the DIP lender would get. And I pause there just for a second, because I've been in a couple of Chapter 11s now that have actually been dismissed at the DIP lending stage, either because one, the court didn't think there was sufficient security available for there to be a super priority status for the DIP lender, or two, it was the third or fourth DIP loan and the court just said, you know, this isn't working. You're forced to liquidate. So I would just note that the DIP lending isn't always a slam dunk. So I do think that is something to consider as well. You know, you need to make sure when you just don't assume that you have a DIP lender in place, everything's going to be fine. You know, you have to make sure that that DIP lender does have the adequate priority status available to them.
Right. I mean, that's one of the reasons why someone would want to make a DIP loan, is because they would be getting a super priority lien above even those liens of the pre-petition, pre-bankruptcy secured lenders.
Right.
Otherwise, why would anybody make a DIP loan? Of course, from a legal perspective, the debtor has to prove that they can't find financing on an unsecured basis. They can't find junior secured DIP financing. Those are kind of the things you have to prove in order to obtain those super priority liens for a DIP lender. Laura, when you're working with a company prior to a bankruptcy filing, how are you guys seeking out financing for that company? Who do you guys talk to? If you could just give us a little bit of that process, a little bit of insight into that process, that would be great.
Sure, happy to, Josh. You know, look, in my experience, that 8 or 9 times out of 10, your DIP lender is your existing lender or lenders, for exactly the reasons that you and Amanda mentioned, which is those lenders don't want to be primed, or there's insufficient collateral, excess collateral to allow somebody else to come in. So the first conversation is with the existing lender to inquire whether they're willing to provide it, assuming that there's an exit plan that makes sense, whether it's effectuating a sale process, or if you have a plan of reorganization that's largely been worked out pre-petition, and so you know you're going to be in and out very, very quickly, and the lender has a pretty good idea of what their recovery looks like under that scenario, then oftentimes the existing lender is also your DIP lender. As you both mentioned, you do have to demonstrate that it's on market terms and that you have effectively shopped. So you will go out and seek other competitive bids to the extent there are other bids that come forth, and certainly you're shopping the terms, whether it's the interest rate or what have you. And that's something that needs to be put on record with the court in order to get that DIP loan approved. We have a circumstance now where the buyer is providing the DIP financing in a current case, but obviously had sought and gained approval from the pre-petition lenders for that buyer to come in on that status. So that's really the other place where I see somebody different than the existing lenders come in to provide the DIP. Otherwise, you just risk having that priming fight, which there was an automotive case where that took place a couple of months ago, right? Where ultimately the pre-petition secured lender had to get paid out in order for new DIP financing to come in, because there was not a meeting of the minds or agreement there. But oftentimes it is your pre-petition lender, or in some cases, you know, working with Roy and other investment bankers, it could be the buyer under certain circumstances as well.
And how long does that process take? You know, I would guess you can't just do it 2 days before you file.
No, we try to get as much work done as possible before filing if we determine that we have to. So that includes the short-term forecast, meaning the weekly forecast. If there's a longer monthly forecast that needs to be done, certainly negotiating the DIP, securing the DIP, trying to line up as many of the constituents as you possibly can. So it's just much more cost effective to do as much as you can outside of bankruptcy and before filing in order to speed your exit, so to speak, or to make it as cost effective as possible. So in an ideal situation, you know, it's probably at least a month, if not 2, if you have that luxury of time in certain middle market cases to be able to put all that together. But even that is a full out sprint. We have a matter where we were brought in after the company had filed and without a dip. And so we did it in about 4 days, including putting the projection together and negotiating the dip. So it's not a very pleasant way to spend those 4 days, but certainly can be done on a much more expedited basis. But usually try to have a little bit more time so you can just make sure everything again is lined up and you have the constituents in agreement with what you want to do to try to avoid objections and to smooth the Chapter 11 process once you do file.
Yeah, I mean, certainly in my experience, when the parties walk into court holding hands, the judge is a lot more receptive to giving the parties what they want. Roy, let's move on to 363 sales, which I know you have experience, doing that and working with distressed companies, both in bankruptcy and out. But why don't you give us a short background about the difference between the marketing process for a distressed company as opposed to a non-distressed company?
Sure, Josh. I think the in general, I think we feel like there's more similarity than there is difference between marketing and business in bankruptcy or outside. Ideally, when we're, like, for instance, in this example that you have here, we'd be marketing the business pre-petition. And we enter Chapter 11 with stalking horse and negotiated bid procedures. But it doesn't always happen that way. Sometimes, as kind of Amanda was talking about earlier, where you're playing defense, company may end up needing to file before all this is lined up. But I think what is almost always the case is that time's just not our friend. And that's true in both outside bankruptcy and inside bankruptcy, but particularly true in these distress situations. Time erodes value and uncertainty erodes value. You just have instances where the business is most likely oftentimes not performing. That's why that's one of the things that led it into bankruptcy. And so that unprofitability exacerbates and becomes a form of value erosion. Customers may seek to resource business or may stop awarding new business. And so that's a form of value erosion. And sometimes it's difficult to retain employees. So those are all things that you have to pay particular attention to. I'd say are in a bankruptcy situation that are unique. And then I think the other thing that's unique to the bankruptcy process, or a difference, is that you're following the bankruptcy, the sale order. So, for instance, once the motion's filed and a sale order comes, then we're making sure that our process mirrors the sale order process. In this example that you have up here, this is kind of a typical sale process. And I think and you see some of the similarities. The similarities is that we need to succinctly communicate the value proposition of the business, qualitatively and quantitatively. And then we need to get in front of the right buyers, both strategic and financial. I think in the case of a bankruptcy, sometimes quantifying or showing the value proposition can be a little bit challenging. And that's where we work real closely with like Laura's group to build a bridge to profitability, really outline those things that are driving it to, that are one time in nature or that are opportunities for improvement, being able to demonstrate and depict that to a potential buyer. And I think the other thing that when we talk about who the right potential buyers are, we're looking at both strategic and financial. One of the things that this pictorial shows it's kind of the optionality of going to market and whether you use a kind of a full sale process, focused process, or a narrow process. And in bankruptcy, we tend to lean toward a full sale process. One is because oftentimes the confidentiality is not as critical as with a private company. If we're already in the process, then it becomes very public. And the other is that in order to go through the bankruptcy approval process, it's very helpful to be able to demonstrate that a full marketing process was used. So those are some of the things, Josh, I think that we see as far as like comparing and contrasting to in and outside of bankruptcy.
That's very helpful. Yeah, I think having to show that you marketed the assets as much as possible and got the highest and best offer is something that you need to prove to a bankruptcy judge. Amanda, as far as the sale process goes, could you give us a little bit of insight into the sorts of processes that you need to have approved by the court? So the bid procedures and the auction process. And before you go, I should have mentioned this a long time ago, but if anyone has any questions, feel free to throw them in the Q&A on your screen, and we will try to get to them either during or at the end of the presentation. But Amanda, if you could just talk a little bit about what a borrower/debtor has to do from a legal perspective to get the sale process approved and eventually get the sale approved.
Yeah, for sure. So I guess from an initial standpoint, you want to market the business, like Roy was saying, and then from there, not every sale, but majority of them, I would say, for 363 sales, you have a stalking horse bidder, and the stalking horse bidder is someone that the debtor has to prove, and its best business judgment is the highest and best offer out there. So you would file a motion with the court seeking to approve the stalking horse bidder purchase agreement, and then also in addition to that, approve the bidding procedures that would all be laid out, and that would be, the bid deadline, what the minimum bid has to be, what the breakup fee, and expense reimbursement cost will be if there's a sale to another party besides the stalking horse bidder. And you would also need to lay forth, set forth all the auction processes, like what are the bid increments going to be? Is there going to be a court reporter? Is there to record the auction? Are you going to allow everyone and their brother to come to the auction, or just the bidders? Things like that, that are some of them minor housekeeping, but matter. And then also, so once the bidding procedures are approved by the court, you have to usually send notice out of that to all of the interested buyers, which goes back to Roy's point of like, who do you market to? Or who do you send the notice of the auction to? It's the same idea. And then you obviously conduct the auction, and then typically you go back to the court for approval of whoever won at the auction. Sometimes it's the stalking horse bidder, sometimes it's not. And typically, if it's not the stalking horse bidder, you will end up back in front of the court to get approval of that sale, and you'll have to show the court that that is the next highest and best offer, or that trumps the stalking horse bid. Or sometimes you can draft the bidding procedures motion such that if the sale does not go to anyone but the stalking horse bidder, or if the auction results in the stalking horse bidder being the highest and best offer, the sale can be completed without further hearing from the court.
So when there's a case about 5 years ago that Amanda and Josh, all three of our firms were involved in, where we didn't run a singular auction. As you'll recall, we ran it both in whole and in part to try to see what would be the highest and best, and were the sum of the pieces greater than the whole, which is what we found in that case. So Amanda, to your point, laying out exactly how the auction is going to be run, and if you want that flexibility, can be pretty helpful, because if you don't have that laid out up front, it makes it difficult to try to have that optionality at a later point. And both you guys did a great job making sure that the debtor had that flexibility, and we could achieve that result in that case.
Yeah, good point, Laura.
And Roy, I think you've talked about too, that the ability to sell assets piecemeal does give, it does make your job, while maybe a little bit more complex, you might be able to extract more value there.
Yeah, good points. I think that additional value can kind of come in from two angles. One is you just have different buyers that may have different interests in particular assets. It's one facility, say, is a better strategic fit for a particular buyer, either from a geography perspective or products or capabilities or customers. And they have less interest in another one. And so when you combine it, you get a less full value than from two buyers that both have strategic interests in both facilities. The other way that could be value accretive is if one of them is profitable and the other one isn't, but has good assets, has strong assets, attractive assets. So you might have kind of an asset-oriented valuation on, say, plant A, and then a cash flow-driven valuation on plant B. And when you combine them, it's lessening the kind of the overall valuation than if you were to look at each of them under the two separate valuation lenses.
I mean, I think the bottom line is everyone is saying that you have to be flexible in this process, because every case is different, and there's always a surprise around the corner that you're not expecting. I would just quickly note that a lot of times, or most of the time, the DIP lender or the senior secured lender who's allowing the company to use its cash collateral during the case to finance it will require certain milestones. So they will say you need to have a sale completed by 90 days after the date the bankruptcy case is filed. And if you don't, that's a trip, you trip your covenant, and the whole bankruptcy case could be shut down by the lender. So it's really important to have key milestones and to have those all set out before you go into court and get that approval, because it's a lot harder to change them once they've already been approved, rather than to have everything negotiated and agreed to before you go into court. We're running short on time. We have about 10 minutes or so left. So let's try to run through some risks and other considerations that we talk about. Laura, one of them, and Roy, the value of the business is not necessarily just the assets that a company has, but a lot of times it's their employees, management team, and its customer base. What sort of messaging do you guys have to give out to those parties, and how is that impacted by the Chapter 11 process?
Roy, you want to go first, or?
Sure. Yeah. So I mean, I think retaining employees and customers just becomes super critical, I think, to the overall, well, from a sale perspective, or if you're going to merge, right? And so I think a lot of those things, you're trying to have those discussions with customers ahead of time, so that they're not surprised, so that you're getting in front of the message, they understand the plan. And then same thing with your employees, especially key employees. And I think that becomes very kind of one-on-one. I mean, I think the borrower, in this case, the owner of a business or what have you, has the relationship with those employees, and needs to have a certain amount of transparency with them in order to communicate what the situation is, what the plan is, and what the exit plan is, and what the opportunities are for those employees. And in certain cases, you end up having retention agreements in order to solidify their position, and that they're going to be there for a period of time. And then on the customer side, we talked a little bit earlier about customer accommodation agreements, which you can only really get if you have leverage and that those customers kind of need your continued supply. I think that's, go ahead, Laura. I think that's really right up your alley right there.
Yeah, no, I was just going to follow on to your comment as it relates to the accommodation agreements. Is frequently those will have a no resourcing clause associated with them. So whether it's Roy or myself or the combination of financial and legal advisors, right? You're generally picking up the phone and calling not only the customer but their legal advisor and their financial advisor and trying to secure either potentially incremental work, in some cases financial accommodations, but certainly a no resourcing clause so that you can keep that customer base in place, or the vast majority of the customer base in place, so that the sale process can be run and value can be maximized and protected. Likewise, Roy hit it. It's the employees are an absolutely critical piece of it, and it is very, very common to have competitors come in and try to poach the good employees, right, with tales of horror in terms of them not having a job at a later point, not knowing who they're going to work for. And look, most people don't understand bankruptcy the way the folks that are participating in this webinar, right, whether it's the panel or the participants. And so the process just sounds scary. Chapter 11 to a lot of people mean you're going out of business. And so it does require a lot of communication with the employees. We wind up doing town halls very frequently. Sometimes there's a written communication that goes out to the employees, but if you let out a written communication, you have to be comfortable that that's going to go lots of other places, not just into employee inboxes. You can find that in the press, find that with vendors, find that with competitors and the like. But we try to communicate early, often, put those retention agreements in place, giving out our cell phone numbers and emails certainly to folks, and encouraging them to call us if at any point they feel uncomfortable or nervous about something, so that we can maintain a direct relationship with them as well, and answer their questions as directly and as quickly, to try to again maintain that employee base, particularly the key employees, to get to the other side.
Thanks, guys. Yeah, it's there's a lot of moving parts, I think, is the bottom line, and communication is key, and having a communication strategy is certainly key, so that you can maintain the value of the company during the initial days of the Chapter 11 and then throughout until you get to some sort of exit. I want to be respectful of everyone's time. We have about 5 minutes, and I know people are staying on not just to hear us talk, but to do some networking after we're done. So we can kind of quickly jump through some of the the unique issues with a Chapter 11 process. You have a creditors committee, you have a United States trustee. It's a very public process, as we've talked about. So everything is scrutinized, not just by management and by management's professionals, and not just by the bank, but there's now a creditors committee whose fees are funded by the bankruptcy estate, who has a say in everything, and they can cause major issues, not just for the end strategy of the company, but also they have the right to investigate the bank's liens. Ultimately, they can even file lawsuits against insiders or seek leave to do so from the bankruptcy court. And we've kind of touched on the fact that it's sometimes an expensive process, but oftentimes if it's done right, it's worth the cost. And then the importance of, as Laura and Roy talked about, maintaining support of the creditors, both secured and unsecured. If it's a larger case, that's just going to be a lot of people who we need to keep happy as a borrower / debtor. Just to end with end on the downside, if things don't work out, what's our alternative? You guys have maybe already seen the out-of-court workout, so hopefully people can work things out consensually without a process. Chapter 7 is a straight-up liquidation where the company loses control. Amanda, you and I are involved in a few of these assignments for the benefit of creditors. If you could give us a quick 60-second breakdown of what an ABC is, and how that differs from a bankruptcy case?
Sure. An ABC, which as Josh and I can attest to, is apparently becoming a much more popular method to wind up and liquidate assets of companies. It's basically, I like to refer to it as a state court Chapter 7. A third party gets appointed to take assignment of all the assets of the company with the sole purpose of liquidating those assets and distributing them to creditors in order of their legal priority. It is filed with the court. However, there's very little court oversight, and it's very there's very little regulation, if you will. I mean, the Michigan state statutes govern how the case operates, but for the most part, the assignee can just come in, sell the assets how he deems fit, in his best business judgment, and move from there. There is the downside with ABC, there is no automatic stay, and typically communicating with creditors can be a little more challenging, either because they don't understand what the process is, or that they think that they can continue to pursue litigation or their claims against a company that quite honestly does no longer exist, except for a bank account with the funds that are in the control of the assignee.
Yeah, I mean, we found that ABCs are a good alternative because as opposed to a Chapter 7 where everything is turned over to a Chapter 7 trustee and the company loses complete control over the process, in an ABC, at least in Michigan and elsewhere, you choose who you're going to assign your assets to.
Great point. Yeah.
And that's very helpful, almost like a receivership. Now, in some states like Illinois, the ABC process is done completely out of court, which means there's even less oversight, and of course there's no judge, there's no creditors committee, so it's a quieter way to wind down an estate. And then real briefly, there's also Article 9 sales under the UCC, where the bank, it's like a foreclosure, and there's also strict foreclosure under Article 9, and sometimes companies just wind down out of court, dissolve, and that's that. But I really appreciate the panelists taking time out of their day to prepare for this and to give us their excellent insight. I mean, we could have gone on for hours, probably would have put in a lot more people to sleep, but it would have been a great discussion, and it already was in an hour. We got a lot done, so I appreciate it. Roy, Amanda, and Laura, thank you for being on the panel. Thank you to the other Amanda with the TMA for helping us organize this. And just a reminder to those of you who are going to stay on and do some virtual networking, there should be another Zoom link either in the chat or it's in the chat. And if you want the slides, as I'm looking, they will be available as well. So please continue to network, and thank you all for your time today.
Thanks, everybody.
Thank you.
Guys.